All right, gentlemen, we certainly appreciate you participating by video and working with us. This is, as I've said several times, a work in progress, and we learn more each time we do it, and we appreciate y'all being involved in it. Um, Before we get started, I want to run over just a few ground rules and introduce the panel. Your panel today is Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. As both of you are experienced practitioners, and you know, each side gets 15 minutes to make its oral argument. If you are the appellant and wish to reserve any rebuttal time, you need to request that from the court after you've introduced yourself and before you begin your oral argument. I want to thank Mr. Hibner. He has worked diligently to put this together and made sure that all the technology works and that the attorneys are connected. And we appreciate him and his efforts. We also appreciate the AOC technology staff. They've done a wonderful job of making this work. So without any further ado, gentlemen, I think both of you still are muted, so you need to unmute yourself before we get started. But Mr. Hibner, if you would call the case, please.
Karthik Rajendran versus Mary Florence Rajendran.
All right, we shall hear from the appellant.
Yes, sir. Thank you, Judge. My name is Alan Emling. I represent the appellant, Mary Rajendran. I am substitute counsel for Gary Williams, who was the attorney who tried this, who unfortunately had to retire medically suddenly because of cancer. I do want to say before we start, Judge, I really appreciate the court's indulgence of me taking over this case. We've been set before, and the court was kind enough to give me time to take over when Mr. Williams suddenly had to retire. So I just want to thank the court for that.
We understand the situation, and we're pleased to do that.
And I would like to reserve 5 minutes for rebuttal. I've already talked to the clerk, and they've set the clock accordingly.
I'm getting some static. I don't know if there's anything you can do about it, but I'm getting some static.
I think it's gone now.
Okay. I only hear it when he talks. Okay, sorry, go ahead.
That's all right. Basically, in this case, this is a divorce case. It was a relatively short-term marriage. The divorce was filed approximately 3 years after the marriage. The child was 3 at the time of the divorce. Our argument is that the court misapplied the guidelines and awarded the father 50-50 residential time, although the court did designate the mother as the primary residential parent. We're also saying that as it relates to educational decisions, that the court erred in making those joint as opposed to the mother. The other 3 decision-making as it relates to as it relates to religious, extracurricular activities, and healthcare, we're not arguing that it should have been joint. In looking at the record, the court found that the court found that 3 of the factors favored mom, 6 were equal, 0 were for dad, and 5 were not applicable. We have some arguments with those. Number 1, which is the factor regarding the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. It's undisputed in this case that the mom was the primary residential parent all through the child's life and was the primary parent up to the time of trial when the court changed the residential schedule significantly from the dad having 3 weekends, well, three-day weekends a month plus other holiday time to 50-50. The court found that to be an equal factor, and even the father admits that the mother had been the primary residential parent, and we think that was an abuse of discretion and was an error and does not look towards the best interest of the child, as clearly the mother had been the primary residential parent all through the child's life, and that is uncontroverted. Also, the second one that we argue about is number 6, which is love, affection, and emotional ties existing between one parent and the other. Now, it's not that we don't think that the father loves his child. I submit to the court that both parties love their child. But the only proof in the record about the other portions of that, the affection, emotional ties existing between each parent and the child, is the father said he wanted the best life for the child and he wanted the child to get the best education possible. The father does not present any indication of their daily life, but he did, the emotional bonding between himself and the child, what they did, no pictures of anything. You can contrast to the mother's proof. And she pointed out that the child was very, very close. She went through in detail what they did at home, what their schedules were, what pre and post daycare schedules were, and all of the activities that she and the child engage in. And we submit that the court, in applying that factor, found that one to be joint, and it should have been one that favored the mother. The third one is number 9, which deals with the relationship in siblings and relatives. Now, the court did find that slightly in the mother's favor. The proof, though, shows that the child has a strong bond with the maternal grandparents and all other maternal relatives, that they all had visited with the mother and the child during the marriage, and that the grandmother and grandfather sometimes came to their house as much as a month, and the mother went to their home on a significant amount of times. You contrast that to the relationship that the father has and the child has with the father's parents. There is absolutely none. They're in India. They've never come to visit in the United States. The father's never taken the child to India, never attempted to do that, at least according to the record. And interestingly enough, the father admitted that he was contributing money to building a house in India. He couldn't really explain why, other than to say that he did that because he held the marriage to Miss Rajendran, to his wife, a secret from his parents because he knew they would not approve. If he held his marriage in secret, I think it's a short stone's throw to realize that they probably don't even realize or didn't realize that they have a grandchild. So the court found that factor to be slightly in the mom's favor. I would submit to the court that that one should be strongly in the mom's favor, especially due to the actions of the father. The last one that in the brief is talked about is the importance of continuity in the child's life and the length of time the child has lived in a satisfactory and stable environment. The court found, again, that one was slightly towards the mother, but we disagree with that finding because, again, the child had lived with the mother consistently since birth until the trial of this matter. The father admits that the mother had been the primary residential parent. And you look at some of the things that the court talks about, and in view, and I know there's a lot of discretion given to the trial court because the trial court actually got to view the witnesses, and there's really only 2 witnesses in this case, which was the mom and the dad. But in our brief on page 30 through 32, I think the trial transcript is quoted. And what's important about that is the sequence of events. And I think the judge just maybe had a little bit of a bad day in this part of the testimony. The father had moved from Franklin to Millersville, Tennessee. And the question is asked of the father, prior to moving, you were living in Williamson County. Is that right? He says that's right. They go through where he works. And the question is asked, okay, do you intend to remain at the Goodlettsville address, which is actually Millersville? It's a Millersville location, but a Goodlettsville address, subsequent to entering the divorce decree in this matter. The answer is no, I do not. I wanted to stay in Williamson County. There are good schools in Williamson County, and he goes on. Then Mr. Meredith says, let me stop you. The court doesn't need to know what you're talking about your friend. What I'm asking you are your intentions after you are divorced from your wife. Where do you intend to live? Mr. Williams objected, and he said that he'd already said Williamson County, and I think the court wrongly said no, he hadn't. And then he's asked again. He says, "Where would you intend to live after your divorce?" I thought I would still live in Williamson County. If that's not a possibility, I would like to live in Sumner County. So his intentions are still that he's going to live in Williamson County, which contradicts some of the things that the court found as favors that were either neutral or only slightly in favor of the mother. I'm sorry, in favor of the father. As it relates to decision-making, these parties have been very contentious. They both agreed it's contentious. They can't agree to anything. The mother testified as to what I would call obsessive behavior by the father, and that's quoted on page 16 of our brief, where she talks about the excessive text messages giving her instructions on what the child should eat, what the child should drink, what her bedtime should be, what time she should get up, what clothes she wears, how she should go to the park. He also talks about what kind of undergarments the child should wear, and make sure that they were 100% cotton, that she's only allowed to eat vegetables, and tried to control things because that's what he does. I also find it interesting that the father made the decision to give the child medication after the judge had, after the court, after the doctor had expressly recommended that medication not been given. The court does ask my client questions as to whether that she thought that the father was being proactive or how that happened, and she basically said she didn't know. So when you take all those factors into consideration, we think that the court erred in moving the residential time from what it was to 50-50. And I know the court really can't resolve that would require a remand for a hearing on that. But the court could fix the decision-making regarding educational. And my time's up. Thank you.
Thank you very much. We will now hear from the appellee.
Morning, Your Honors. Brandon Meredith on behalf of the appellee Karthik Rajendran. Certainly, we feel that the trial court entered a permanent parenting plan consistent with Tennessee law, taking into account the statutory factors at 36.6.106 and the directive in that statute to maximize each parent's parenting time with the child as can be done consistent with those factors. And we're also mindful of TCA 36.6.401 and its directive that or finding by the Tennessee General Assembly that the parent-child relationship with each parent is to be fostered whenever that can be achieved. Now, with all due respect to Mrs. Rajendran and her counsel, there's plenty, we believe, in the record to support the trial court's findings. With respect to Section 1, the strength, nature, stability of the child's relationship with each parent, and whether each child has performed the majority of the parenting responsibilities, I disagree to the extent that Mr. Emling argues that is tantamount to an analysis of who served as the primary residential parent as of the time of trial. That, in essence, is his argument, but that statutory factor is set forth in number 5 of TCA 36.6.106, and the trial court plainly found that to be in the mother's favor. So to give her credit for both, or to find in her favor with respect to 1 and 5 based on the fact that she was a stay-at-home mother, I think would be a step too far. Now, there's nothing in the record, as we've argued in our brief, to suggest that either parent is deficient in any regard. No proof was put on to support that finding. Trial court specifically found that it was dealing with two older parents who had a profound love for their child, who was an only child, and the court went on at some length discussing why it felt that was important, and acknowledging that each parent loved Amy. And I don't think that there's anything to refute that. I certainly don't think that there's anything in the record that would support this court finding that the trial court abused its discretion by finding that the first statutory factor was equal. With respect,
let me ask you a question, Mr. Meredith. I have looked at the, I guess the attached transcript, and I'm a little concerned because I'm trying to ascertain the court's reasoning as to finding which particular factor is applicable or how it favors either parent. For instance, he talks about the first factor and says strength, nature, and stability of the child's relationship with each parent, including whether one has performed the majority of parenting responsibilities relating to the daily needs of the child. And in this case, even though the mother has had more time, I do think the father's been able to take care of her family needs of Amy when he's had her. So I find that to be an equal factor. Is that good enough?
well, Your Honor, I think, and this is a point that we've argued in our brief, I think in cases like this, the court has to look at both the positive proof and the proof that's not in the record. There was no suggestion at the trial that there were any issues with the father's exercise of his parenting time, even though it was limited at that time. The mother put on absolutely no proof that there were issues or that there was a problem with the father's ability to care for Amy during his parenting time. And in fact, she recognized that he loved his daughter greatly, and in her view, Amy would adjust perfectly fine to any increase in his parenting time. So I understand the court's concern about who's performed the majority of the parenting responsibilities, but again, I don't necessarily think that strictly means number one must go in favor of the parent who has served as the primary residential parent. I think that is addressed in the fifth factor. And I think the court was also cognizant of the fact that at the time that it entered its temporary parenting plan order in July of 17, it really was appropriate then to make the mother the temporary residential parent and give her the majority of the time. I think that the dichotomy there was 70% for the mother, roughly 30% parenting time for the father. But that was based upon the fact that the mother had been a stay-at-home mother. She was not working at that time, and the judge saw no purpose or reason to create a situation where Amy's being pulled out of that situation and put in childcare, for instance, when the mother was still staying at home. But he pretty plainly articulated what would happen in the future based upon the expectation that both parties would obtain full-time employment, which they had by the time of trial. And the stability in the situation that existed at the time of the temporary order, where the mother's favored essentially in terms of the parenting schedule, those facts no longer existed as of the trial date. Mother admitted that her situation had changed. She was working full-time. Childcare was going to be a daily requirement for her, just as it would be for the father during his parenting time. So the idea that she would continue to be a stay-at-home mother and exercise that very substantial parenting time was no longer an option, which is usually the case when any party is divorced.
I don't think I perhaps asked my question as artfully as I should have. When the court recites the factor and then says, I find that favors father or mother, is the court required to explain why that factor favors father or mother or is equal? Or is it simply okay for the court to simply say this factor favors father, it favors mother?
Well, Your Honor, truthfully, I think in a perfect world, this court would prefer that the trial judges take that extra step and recite back to the record for the specific facts that it's relying on by making the finding with respect to each parent. But I think what we have to do in a situation like this is look at the record as a whole, and does the record as a whole support what the trial court ultimately determined with respect to each factor.
So how do we know what the court considered if the court didn't tell us what it considered?
Well, again, I believe that's a fair point you're making, Your Honor. But what the court considered here is, in my view, appropriate, which was the lack of any proof to the contrary that the father's having issues with his parenting time, and the fact that the trial court was not going to simply continue the temporary order and find that was dispositive of the parenting plan issue at the final hearing, simply because of the facts that existed at the time that order was entered. I think that's what the court was relying on, and I think that's reflected in the judge's ruling, where he's basically saying this is the only reason it would have gone to the mother in that particular instance would have been based upon the fact that she had more time with the father or with the child based upon his temporary order. And I think that's what he was not going to do. And I think that's appropriate. In looking at the permanent parenting plan statute, it directs the courts not to draw presumptions from the temporary parenting plan orders. And I think that's what the judge did in that regard, was consistent with that particular statute.
I understand you're not to draw presumptions, but in this case, wasn't that the evidence, essentially?
Well, it is pertinent evidence, yes, Your Honor, and I don't think it can be ignored. But, there was nothing in the record to suggest that the father did not have a strong relationship with the child. The stability, again, that's referenced in Section 1, the facts had changed so significantly from the time of the temporary order to the trial that stability was already gone. So what we're basing...
How do we know that, since the court
I would submit is
didn't say anything about stability, did it? I mean, it looked at the factors.
Your Honor, you cut out.
Oh, I'm sorry. How do we know that when the court didn't explain its stability finding?
Well, I think if you'll bear with me a moment, Your Honor.
Yes,
I think later in the judge's ruling, he does more specifically address the stability factor. Well, and Your Honor, it may not be sufficient from the court's point of view, but the test or the judge's ruling that I was referencing is found on page 16 of the transcript, which we attached to the final decree, starting at line 12, where the court noted that, and quoting, "So I am concerned about stability. I'm concerned about changes for Amy, but I haven't heard anything today that leads me to believe that ultimately equal parenting time should not be accomplished." So, the court is entertaining the notion of stability. And I think in that regard, there's a key point of the parenting plan that needs to be remembered. And that's the trial was in December of 18. The court did not change the residential schedule immediately after the trial. There was a 6-month period where the temporary plan continued. The judge's thinking being that we're going to talk to Amy about this and these potential changes, and starting in July of 19, we're going to move to an equal parenting time arrangement to maximize the father's participation in his daughter's life. So again, I think the court was very mindful of the stability factor and took it into account in fashioning a ruling that made sense under the various factors and the facts presented to the court. With respect to, and I guess since I'm running close to time, another point that I think needs to be made strenuously is that this court has been clear in the past, and we've cited the cases in our brief, that reviewing 36-6-106, it's not a math problem where we create 2 columns and we put marks for the mother and the father in each one, and then at the end of the 15 factors we say, well, mother has 6, father has 4, and 5 don't apply, therefore mother is primary residential parent and has substantially more parenting time. That's not how the statute is set up. And so, to that point, even if Mr. Emling is correct, let's assume that number 1 should have been found in favor of the mother, and number 6 should have been found in favor of the mother. At the end of the analysis, that's 2 more factors in her favor, which would be 5. We would have, I believe, 5 that still don't apply. We would have, instead of 6 that were found to be equal, we would have 4 that are equal. But what does that mean in the end? Does it mean that the trial court actually abused its discretion by ordering equal parenting time, given what the legislature has told us the court is supposed to do to maximize parenting time? I don't think that it does. In a related point, we've cited these cases in our brief. The Abed case, I think, is very important to note, because in that case, you had a father requesting equal parenting time, testimony that he was able to fulfill equal parenting arrangement, no issues with his employment, no limiting factors that would lead the court to limit his time to something beyond maximizing the time. And he was placed on an every other weekend or standard visitation arrangement. And in that case, this court found that was an abuse of discretion by the trial court. So, looking at what the mother proposed here, at the time of trial, she thought that the father should have 108 days of visitation. I would submit that had the trial court gone that far, based upon the facts and circumstances, the review of the factors, the father's desire to maximize time with his daughter, I think that would have been an abuse of discretion. I certainly don't think that the trial court trying to maximize the father's involvement. I apologize, I'm out of time.
It's okay. We appreciate your argument, appreciate your response. Mr. Emling, I believe you've got 5 minutes. Mr. Emling, your mic's muted.
Apologize.
There you go.
In response to what the court's question was, I'm going to quote what the judge said in response to factor number 1, and that's on page 196 of the transcript. It says, and in this case, even though the mother has had more time, I do think the father has been able to take care of her daily needs of Amy when he's had her. So I find that to be an equal factor. I think that's deficient in his reasoning for a lot of reasons, because the factor itself talks about who has had the child, who's performed the majority of parenting responsibilities relating to the daily needs of the child. It's undisputed in this case that had been the mother from birth. Also, I found it very interesting in the trial court's decision before the judge goes through the factors. He says he has this, and I'm using air quotes, precondition, that the precondition is the parties will keep residences in Sumner County. Now, I've already talked about that he's kind of unsure about that, and I quoted from the trial transcript where he basically says twice that it's his intention to go to Williamson County, and he also has this house in India. So we don't really know where he's going. And so to answer the court's question, I think that the trial court is required not only to decide which factor favors or one party or the other, or is equal or is not applicable. I think that the trial court is required to give a reason for whatever that finding might be. So when somebody like the Court of Appeals here is trying to review it, they can look at the rational decision the judge made and make sure that it matches the evidence. I also think it's something that hasn't been talked about. The father was given 3 days in the temporary parenting plan because he said he could work from home on the Friday, and therefore he would be with the child the whole day. And then what happens, basically right after that order goes down, the dad puts the child in daycare. So again, that would relate to this factor where he's not exercising that parenting time or performing the majority of the parenting responsibilities for the child. And all of these factors, yes, it's not an add them up and see how many is on one side or the other, and that determines how much parenting time you get. But the strength of how these factors fall in one side's camp or the other affects what the court can determine about child custody and residential time, including the fact that one party says they're going to be at home with the child, and then they turn around and don't do that after the court awards them some time. I think that's problematical for the father in this matter. I also think it's problematical for the father where we're talking about parenting time and the educational decisions. He talks a lot about those things, but he's all looking in Hendersonville, Tennessee. But he doesn't live in Hendersonville, Tennessee. He lives in Millersville, and he is not zoned for any of the schools that he talks about. And the daycare that he talks about, he brought up, he investigated the day before trial, which I think shows a little bit of disingenuousness. The father does a lot of things right at the last second because, and this is just my opinion, it looks like he's trying to position himself and or make himself look the best. He was going to be home. He puts her in daycare. He wants her to go to the best schools, but he doesn't live where he says those best schools are. And he chose, when he moved from Williamson County to Millersville with the Goodlettsville address, he chose the location. And so then suddenly he says, well, no, the best schools are in Hendersonville. Mom is in Gallatin. And there was no question that mom's choice of residence and where she was related to the best interest of the child because the daycares were close, the schools were close that the child would be attending. And so she was clearly looking out for the best interest of the child. And when you use that best interest analysis, I submit to the court that the decision to give equal time was an overstep and abuse of discretion. And again, that also relates to the decision-making thing that I talked about earlier, where the mother is requesting that she be given the decision-making authority for educational decisions. And that's mainly because of the problems that I just pointed out, that the father has a tendency to what I would call pie in the sky, in the sense that what he wants is not feasible with where he lives. And my time is up. Thank you very much.
Thank you, gentlemen. We appreciate your arguments. We will review the record and we'll attempt to get you an opinion as quickly as possible. Again, we appreciate you participating in this video oral argument. I thank again Mr. Hibner and the AOC. And I believe that concludes this case, Mr. Hibner.
This honorable court is now in recess until 11 a.m.
Thank you.
Thank you.